So far we've spent a lot of time talking about the separation of powers, talking about examples of where the separation of powers has been seen within case law, and now what I want to do is examine the specific areas of the separation of powers by deconstructing each of the branch and the relationship that they have. We're going to begin with this video by looking at the relationship between the executive branch and Parliament, so the relationship between government and Parliament effectively, if we wanted to be more specific, the relationship between government and Parliament. And then in the next video what I want to do is look at the relationship between these two branches of government and the judiciary. So really effectively we're going to continue these last two videos on the separation of powers by talking about the potential fusion of powers that exists between the government and Parliament, and to what extent this is really a fusion of powers, and then to what extent this is a good or a bad thing, because there are some legal theorists who would argue that despite there being a fusion of powers between the executive and Parliament, that this is actually not even a bad thing. And this is what we're going to begin with. So really, according to Walter Bagehot, from his seminal piece in 1876 called The English Constitution, he suggested that the fusion of powers between the functions of government made them more effective. So the fusion of powers between the executive branch, and Parliament, the legislative branch, this fusion of powers existed, so there was a fusion of powers, but B, it didn't necessarily mean that this was a bad thing, because he argues that this functions as being able to allow the government to become more effective in this role. And by that we can talk about the passing of legislation, as well as things like administrative law, so administration, which is, as we looked at in the first video, these are the two functions of A, the legislature, and B, the executive, to organise through policy and to also pass and make laws. And these are made more effective by there being a fusion of powers between the two branches of government. That's what is argued in the English Constitution. On the other hand, you've got the argument that the fusion of powers does not exist in the same way as it's represented. L.S. Emery argued that despite there being two branches, despite the two branches being represented in the same institution, i.e. both being represented in Parliament, despite them both being represented in Parliament, they are still nonetheless separate. So even though they operate within the same chamber, within the House of Commons, for example, as an example, government and Parliament, no matter how closely linked, are still separate and independent entities. So while there might be physical links, so a physical link here, they still are separate and independent. And this is due to a number of factors, one of them being the historical origins. Don't forget, Parliament and the executive branch developed at different times within history, and this is partly due to the relationship between Parliament and the monarchy. They also have their own methods, and they have their own functions. So they have their own methods as well as their own functions. So generally speaking, this implies that even if the two branches of government are very close, they're very close together in terms of being both represented in the same institution, they are not necessarily fused. Their powers aren't necessarily fused, which is a very interesting example. And so really, if we're going to suggest that there is some kind of separation of powers, the question then is, to what extent is there a separation of powers between these two institutions? So between these institutions. And a very good argument a very good way to argue that there is a separation of powers, and to a more of a modest extent, you could talk about the fact that you can show a system of checks and balances. Don't forget, from the first video we talked about the principles of the separation of powers, the third principle being one branch can check and balance the powers of another, and vice versa. And so really we can devolve this question of to what extent is there a separation of powers between the executive and the legislature, and we can talk about to what extent are there these checks and balances between the two branches. And there is a very strong argument that there is a few checks and balances in place. Now, what I'm going to do is I'm going to list off and give examples of the checks and balances from the legislature, the checks from the legislature on the executive. What I want to do is for you in the comments to work out what kind of checks and balances go the opposite way. What kind of government checks are there over Parliament? And it would be very interesting to see what kinds of things you come up with, because you have to also bear in mind the relationship between the royal prerogative and the concept of parliamentary sovereignty. So, what kind of checks and balances does Parliament have over the government? Well, the first one, a very clear example, is the system of ministers and government questions. So this gives MPs an opportunity to question and scrutinise the business of government. And we all can think of a very, very popular example of government questions, which is on Wednesdays, which is Prime Minister's questions, or PMQs as it's called, a very popular part of the week for the politically inclined, shall we say. Now with the questions, you have MPs who will submit questions to government, and it is the responsibility of government ministers and for the Prime Minister as well on Wednesdays to answer these questions to the best of their ability. And this happens throughout the week. You have different questions levied at different departments, for example, Department of Education, Department of Health, and you also have the big one on Wednesdays, which is to the Prime Minister. Parliament also checks the work of government through parliamentary debates. So whenever a piece of legislation is submitted in the form of a bill, there are a number of debates, and we will get back to this when we talk about the legislative process. So when we talk about the legislative process, we will discuss this in a little bit more detail. But parliamentary debates allow for all of Parliament to debate bills that are submitted by the government, and it's usually the government that submits bills to the floor to have debates. With this be done through the first and second readings and stuff, but it also can be done through the committee system. So this is also done through the committee system. And again, we're going to discuss the committee system when we come on to the legal role of the legislature within the Constitution. But for now, just to note that a way in which Parliament checks the government's power is through debating bills that are put forward to Parliament, and to ultimately vote on those bills. Now, most of the time, government has a majority within the Houses of Parliament, within Parliament itself, or at least the government party does. However, there are still some examples where voting is important, where it provides an important check on the government. And even if the piece of legislation does get passed within the House of Commons, for example, the voting behaviours of MPs also still signify a very important check on government power. So when it comes to checks and balances, we can see that there are definitely parliamentary checks on the government. So we have Parliament here checking the government. We do have parliamentary checks on the government, okay. However, to what extent is there is there government checks on Parliament? So that's really the question. To what extent does this arrow point the other way? Because if we talked about the US Constitution for a second, which we always like to do in this series, as it seems, there are checks and balances going both ways. So if we talk about, for example, Congress and the presidency for a second, so Congress and the presidency, the kind of checks that Congress has over the presidency, well, it has the Senate has the power to ratify not only treaties that have been been negotiated by the president, judicial appointments and nominations, for example. It also has the power to impeach a president. It also has the power of the purse over presidential legislation, the power of the budget. It also has the power to override a presidential veto. So those are the kinds of checks that can be levied against the president. And on the other hand, Congress, okay, the president has a number of checks against Congress. And this includes the veto, for example. It's a very good example. The veto is a very good check on congressional power. Okay, the president's role as commander-in-chief can also be seen as a check on congressional power to declare war. So these are obviously examples going both ways. So the task for the end of this video to talk about in the comment section is, we've talked about the parliamentary checks on the government. To what extent can the government check the power of Parliament? To what extent do these checks and balances work both ways? And then in the next video, we're going to talk about the extent to which the judiciary is separate to these two other branches of governments. And really, we ask the question is, to what extent is the UK judiciary an independent institution?